Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend, special guest, Russ Cook with Russ Cook & Associates over in Brentwood, Tennessee. Russ is a board-certified estate planning attorney. And we spent part of the time now talking about wills. I want to get into trusts and how they work. Had an earlier caller, Bob, who was talking about his experience with when his aunt passed away down in Florida. And this is one of those areas that, Russ, we were talking a little bit of break that, with a trust, it can help you protect the personal property as well over what a will could do.
Yeah, and especially if you have real property outside the state of Tennessee, the problem is the will does not become effective until you file it, which means the person that's appointed the executor legally doesn't have any authority over the property until they're legally appointed. Well, when you do your estate plan through a revocable trust, the trustee, the successor trustee, legally takes over assets when the person who initially created the trust dies. So they can go in and then kind of, in the case where we were talking about, change the locks on the home to protect people from running straight from the funeral home to the house and trying to get at the assets.
And that's one of the benefits of a trust, basically, is that it's more immediate than, as Russ was just saying. So once you've, with the trust, it's setting up already, doing the work, if you will, of what probate does. I mean, when you have to transfer, what probate's doing is transferring the assets from the name of the deceased over to whoever the beneficiaries are going to be, so that they can then do what they need. So let's say we're talking real estate, personal property, that kind of thing. That allows them now to dispose of those things, to sell to to whomever, or if it's going to go to a family member and they're going to keep it. All that's done. It has to be transferred. The title, the deed, all of that has to be done through the court, unless you have a trust. And if you have a trust, what you're doing in essence is you're putting it in the name of the trust, so you're already doing that work of making those transfers. You're staying in control of the trust during your lifetime, and for husband and wife, that means during both your lifetimes, as the survivor would still stay in control and in charge of all assets. But what it then does is, when both of you are gone, okay, if single person, when you're gone, and you've named now, if you have children or whoever those beneficiaries are going to be, they can step in immediately, all right, take charge of everything, and that allows them if there's concerns about someone coming into the house, they can change the locks on the house. They can make sure that they've got certain, alarms or different things maybe set in place to protect the assets on an empty home. It allows them to move immediately to take care of what needs to be done with regard to distributions. The house is now in the name of the trust, so they can, if they want to put the house on the market or whatever they're going to do is amongst the family, they can go ahead and do that right away. They're not going to have that delay. So that's one advantage. Now, Russ, some other things, when people have property in other states, so we've talked about the probate process, how long that might take, and the fact that it does differ state to state. So it can be more expensive if you've got property in other states going through probate there, but also you're going to have what? Multiple probates, right?
Yeah, exactly. So in the example actually that Bob called in, there was property in Florida. If that person that died was a Tennessee resident and had property in Florida, then we would have to probate the will here in order to get the process started. And then once we did that, we'd have to contact a lawyer in Florida and get the will filed again in Florida and go through probate with respect to that piece of real property.
Right.
And that can be very expensive, especially in Florida, where the procedures are much more onerous than they are in Tennessee.
And there's a lot of times, I know I have a lot of clients that have property in other states. So if you do, now you're going to have multiple probates. That's going to multiply the cost as well. And when it comes to cost, this is one of the things too, by the way, a will is going to be less expensive up front, all right, to take care of, but then you're going to have the cost and all the things we've been talking about related to probate after the fact. So by the time you add that in, the will is actually in the long run going to cost probably twice as much as a trust would cost. But here's the other part. It also depends on the county and the attorney handling it. These costs could possibly be even higher, but that's typically what you're going to pay more for the trust up front, but then you're going to have less cost down the road. And here's an important part of that. If it's one, the trust has to be drafted properly, so you want to make sure you're working with an experienced estate planning attorney. All right, number one. Number two is that when it comes to that trust, it needs to be kept up to date. Like with my clients, this is one of the things we do regular reviews. So when I have a client that when we've done estate planning, or even if we're just handling the finances, we're always looking at things at least once a year, and usually 2 or 3 times a year we do reviews. All right, we do that for tax planning purposes, and we also make sure that the estate planning is kept up. So if we change assets around, if there are different accounts are opened up, whatever it might be, we're making sure that the trust is that asset's either titled to the trust, or the trust is set up typically as a contingent beneficiary. And this is another thing with retirement accounts being one of the largest assets most of us have, is that those accounts, you usually want your spouse, and there are a lot of different rules around that. We won't jump into that right now, but the trust is a contingent, and having the proper language to protect the ability to stretch those accounts out over the lifetime of the beneficiaries, Russ, is so important.
It is, and what also is important to know is that the retirement accounts don't have the same level of creditor protection once they pass down to the next generation. So when you're passing your retirement account down to your kids, you have to take into account if they inherit it, it still is an exposed asset. And what we do, the reason we like the revocable trust is that it allows us to create an entity to receive that retirement account, not go directly to the kids, but have the trust receive it, and then set up the trust in such a way that you can look through the trust at the child's life expectancy for determining the payout. So you get the same level of income tax treatment as you would if it went directly to the child, but you get the added asset protection treatment because it goes to the trust.
Right, and this is one of the advantages with the trust. When it comes to this too, you don't necessarily have to. You can have a trust, by the way, that can stay open, and that trust, when it's for other assets, for instance. An example would be husband and wife. This is one we run into quite commonly. It's not unusual today. In fact, it's more common than not, probably, where people maybe were married before and they're coming together in a second marriage. They have children from the first marriage. They want to protect the children from those with their personal assets. Are saying, so I want my stuff to go to my kids and your stuff to go to your kids, but we also are going to have things together, and we want to make sure that if when one of us predeceases the other, that surviving spouse is going to be taken care of. So we might want them to be able to live in the house, and then when they're gone, we might want that house to be sold and divided between the respective families, okay, depending on how those assets have been put together. So there's a lot more planning you can do with a trust that gets into this kind of detail, and why it's so important to keep this up. Now we're going to have to take a break, and we're getting going on the trust part, so I want to jump right back in when we come back, because there's a lot more to be covered and a lot more advantages that can be had with a trust. I've always loved the way using trust in planning, and most of my accounts, with rare exception, that's what we recommend. So join us here. We're going to get into this even further when we get back here on the Retirement Report.